testimony intended is directly relevant and would outweigh any qualified privilege. Quote, an intervener must be asserting an interest that is part of the subject matter of the litigation, unquote, Hudson versus Jarrett, 269 Virginia 24 at 32. Here, as Mr. Tobin stated, TMZ seeks to protect potential information solicited from a third-party witness, which is in no way a matter before this court, citing Commonwealth versus Gill, 89 Virginia Circuit 323, a 2014 case denying a motion to intervene where the intervener filed it, quote, to protect a property right, not a matter before the court, unquote. The outcome of this trial will not affect TMZ, and it does not have a sufficient interest in the subject matter of this suit to intervene. See Texas Fletcher, Maiden and Reed, PC versus Bank National Trust Co., 2013 Westlaw 5849140, granting, and this is distinguishing it, granting the motion to intervene where the intervener's liability would be affected by the outcome of the litigation. Finally, Your Honor, TMZ lacks standing to object to testimony by a third party in this action because TMZ, as Your Honor pointed out, is not being compelled to testify. TMZ's reliance on the Philip Morris case for the proposition that the privilege cannot be circumvented by seeking confidential source information from an employee is inapposite. 36 VA Circuit at 1. For one thing, as noted in that case, there is no testimonial privilege akin to that enjoyed under the Fifth Amendment, which would allow a reporter to refuse to appear before a grand jury and answer questions. And Philip Morris, as Your Honor is aware, the party issued a third-party subpoena for records to trace confidential sources. Philip Morris is inapposite here, as that case related, as this case is related to witness testimony, not records. As Your Honor suggested, TMZ's quarrel, if any, is with Mr. Tremaine to the extent that he had an NDA that was enforceable, applicable, and that's not what we're hearing from Mr. Tobin. So to the extent that TMZ, which is not exactly Edward R. Murrow, Your Honor, to the extent they have a beef, as it were, a cognizable beef, it is with Mr. Tremaine. It is not with Mr. Depp, and they clearly do not have standing to assert or to intervene because they are not intervening as a party, plaintiff, or defendant. So we respectfully submit, to the extent the court disagrees, I can go into the arguments why the privilege is inapplicable, but I will reserve that.
Thank you. All right. Yes, ma'am.
Your Honor, I would like to weigh in from just a different perspective,
Okay.
and that is because we're trying to deal with some important issues of privilege, et cetera. But from our perspective, representing Ms. Hurd, we have issues with this witness separately, and I want to make them very clear for the record. This is somebody who should have been identified in discovery, was never. Second of all, it's not relevant whether, apparently what they're saying he's going to testify, and we have not had the opportunity to discover that, is he's going to claim that someone leaked to TMZ that Ms. Hurd was going to obtain the TRO on that Friday and also leak the video, the kitchen video with Mr. Depp being rather violent. I'm almost certain he's not going to claim it's Ms. Hurd, so I think it's never going to come in.
Right. Ms. Berhoff, I understand all that argument. Do you have any argument as to this particular motion?
No,
okay, well, then we can address you.
My point is, though, if you balance the prejudice versus the probative value, I don't even see how he can come in on foundation or hearsay or relevance.
That's just not part of this motion at this time. Thank you, ma'am. All right, Mr. Tobin, your motion, you get the last word, sir.
Thank you, Your Honor. You know, I appreciate that the court shook your head when he made the snarky comment that this is not Edward R. Murrow. Obviously, the First Amendment applies to everybody, citizens, the New York Times, or TMZ. And this is a First Amendment-based privilege. Your Honor, the Philip Morris case is actually a very good case to answer Your Honor's question about the intervention of somebody else in order to assert the privilege. ABC was a defendant in the case, and it moved in order to prevent other people, the phone company.
Right. But they were already in
airlines.
the case in that particular
I understand.
matter.
There is no other mechanism, though, and so it would be an interesting procedural issue for appeal, Your Honor, whether a journalism organization or anybody else who's a First Amendment holder would be denied intervention on a constitutional-based privilege. I also, just for the record and for the merits of the case, if I understood Mr. Chu correctly, he said this is not an issue in the litigation. This does not relate to an issue in the litigation. Well, if it's not an issue in the litigation, if it's not part of a prima facie part of the defense, part of the allegations of the complaint, if it's impeachment evidence, if it's collateral to the main issues in the case, under the Brown v. Commonwealth decision under the Virginia Supreme Court, under the application of that privilege in the Philip Morris versus ABC News, it is not supposed to be compelled in this case.
Which is, again, it's not being compelled, it appears.
Well, he is appearing by subpoena, and it is a compulsory process, and he will have an obligation unless he asserts privilege under oath. But it is our privilege, Your Honor. It's not an employee, a loyal or a rogue employee's privilege to waive on behalf of its employer. This is an unusual situation.
Tell me about it.
But the answers are there in the law, and it is a First Amendment concern.
This is not the first unusual situation in this case. I can
For
tell you
either
for
of us,
Mr. Tobin.
for anybody here, I'm sure.
Yes, sir. I appreciate you coming in today, and I appreciate your arguments. Yes, sir. Thank you. All right. In this matter, under Virginia Rule Supreme Court 3:14, a new party may intervene as a plaintiff or defendant to assert any claim or defense germane to the subject matter of the proceeding. A new party may not intervene unless they assert some right involved in the underlying litigation. A party is not entitled to intervene merely because a byproduct of the litigation adversely impacts them, and the decision to allow intervention is within the broad discretion of the trial court. Here, the rights asserted are not germane to the trial. The central issues in this case are whether defendant defamed plaintiff and whether plaintiff defamed defendant through a theory of vicarious liability. The issue of the confidentiality of sources has not come up as in other cases cited by EHM, which is the corporation that TMZ belongs to, is under their umbrella. In Brown versus the Commonwealth, there was an attempt by the criminal defendant to subpoena institutions in order to obtain the name of the confidential source. When the author of the article was subpoenaed, she refused to identify her confidential source on the stand. And in this case, it appears that the witness is willing to state the name of the confidential source without being compelled voluntarily. Whether that breaches a non-disclosure agreement between Mr. Tremaine and EHM is not germane to this matter and can be litigated in a separate matter if EHM so chooses. And while breaches of contract must be taken seriously, and the court does, any alleged breach is not germane to the underlying litigation here. That contractual action has no bearing on this case and is thus not germane to this litigation. Therefore, I'll deny the non-party EHM Productions motion to intervene.
Thank you, Your Honor. For the record, I've known Mr. Tobin for several years. I meant no snarkiness toward him.
Well, you're just a snarky guy. Yes, Ashley, Mr.
Your Honor, I am concerned that we preserve the issue fully. And so,
for the record, yes,
for the record. And so I would ask, may I have the opportunity to object when Mr. Tremaine is questioned by question?
No, sir, you're not a party to this case. However, I will note for your record your objection to his complete testimony on behalf of your client.
Right. Thank you, Your Honor.
Okay, thank you.
Your Honor, as with
your microphone, Ms. Burrow.
As with the Hicksville witness, Your Honor, I would ask that we could voir dire him before the jury to find out when he contacted counsel and when they became aware of it. And I think also, under the circumstances, in fairness, I think we should at least be able to ask him what he's going to claim.
Response.
Your Honor, I don't think that's appropriate. appropriate. Certainly, I don't think a proffer is necessary or appropriate in this case.
I'm not going to do a proffer in this matter, okay? All right. Mr. Ruttenberg, I
Sorry.
was almost at lunch.
I know, I'm so sorry. But I truly am the messenger here, because Mr. Murphy just informed me that he has to just clarify one thing
Give me just
about.
one clarification.
Okay,
Your
all
Honor.
right, okay.
I apologize.
That's fine. I think we need Ms. Myers.